Hello and welcome to this video. My name is Rafe McMahon and I am here with Jessica Goldrick, and together we are the two partners of McMahon Goldrick Solicitors. This firm specialises and indeed very much enjoys representing and assisting clients who have been affected by life-changing, also known in the legal world to be called catastrophic injuries.
We exclusively specialise in three categories of injury, and those are catastrophic spinal cord injury, catastrophic brain injury and catastrophic birth injury. When we say catastrophic, we mean life-changing for the individual.
We deal with these injuries whether they arise from a personal injury such as a road traffic accident or workplace injury, or whether they arise from medical negligence, for example during a surgical procedure or negligent obstetric care. This video serves as a guide to those who have suffered from a brain injury. If you or a loved one of yours has unfortunately suffered from a brain injury, and that injury was caused by the negligence or failure of someone else to take proper care, then a case may be brought to receive financial compensation. We are now broadly going to take you through some of the steps that are involved in bringing a claim if you have suffered from a catastrophic brain injury.
The injured person is called a plaintiff, and one of the first things a plaintiff solicitor will need to do is obtain an expert report which positively supports the argument that the brain injury arose as a result of another person or party's negligence. The speciality of that or those experts will depend on how the injury arose. For example, if the injury arose as a result of a personal injury, such as a road traffic accident, that expert may be a forensic engineer. Or if the injury arose as a result of potential medical negligence, for example during a surgery, the expert commenting on negligence might be a neurosurgeon. Depending on the unique circumstances of your case, you may require a number of reports from experts of varying professions before liability and negligence can be established.
It is crucially important for the solicitor to be aware of the deeply unique nature a brain injury is to any particular client. An account should be taken of what the individual was like before the injury, and the family should be alert to any changes in personality should they present themselves. The difficulties may be physical, for example, coordination, balance, swallowing, seizures, incontinence, just to name a few. There may be cognitive changes, for example memory, concentration, problem solving, perceptual difficulties, language difficulties, again just to mention a few. There may also be emotional and behavioural consequences, such as personality change, irritability, lack of awareness, motivation issues, even issues with depression and issues pertaining to sexuality. The solicitor should be alert to which part or parts of the brain have been damaged. The parts of the brain are the different lobes, and each part of the brain controls different bodily functions.
Once we have obtained a support report or reports, we can then begin the process of bringing about proceedings after gliding in and out of the injuries board should that be necessary. Proceedings for catastrophic brain injury claims are issued in the High Court. The person or party who allegedly caused the injury is called the defendant. When your proceedings have been issued, the solicitors for the defendant will obtain their own expert reports which comment on the issues of liability and negligence. To facilitate with their investigation, the solicitors for the defendant will request for your solicitor to issue them with a copy of the relevant medical records and any other records relating to the accident. This process is called discovery.
Broadly, there are three categories of reports that your solicitor will obtain for the purposes of building your case. The first category we have already alluded to and discussed, and these are the reports relating to liability and causation. The second category of reports are medical reports. If appropriate, and as alluded to, some of those reports may be obtained from your treating doctors. It is not unusual to have reports from the GP, a neurologist, a neurosurgeon, a speech therapist, a psychologist, a neuroradiologist, and very importantly, a neuropsychologist, the latter who endeavours to take all the information and assess the impact of the brain injury on the individual.
The third category of reports is quantum reports, and these are the reports which your solicitor will use for the purpose of calculating the bulk of the value of your claim for compensation. Experts under this category can include physiotherapists, occupational therapists, care consultants, housing experts, assistive technology experts, vocational assessors, psychologists, and rehabilitation consultants. These experts will make a number of recommendations to help you live a more independent life moving into the future. For example, the housing expert may advise in relation to the cost of building a home to make it fully accessible. The nursing expert will make recommendations in respect to the number of private care hours that you may require. The occupational therapist will advise in respect of your equipment needs and their associated costs moving into the future. The vocational assessor will ascertain your future loss of earnings. And finally, an actuary will review all of these quantum reports to calculate the total value of those future recommendations.
The costs that have been built up to date will be included in your case. For example, the hours put in by loved ones caring for you will be valued, in addition to your loss of earnings and any monies that you may have put into making adaptations to your home. The solicitors for the defendant will typically obtain like-for-like quantum reports, meaning that for every type of expert your solicitor sends you to, the defendant will arrange for you to see an expert of the same profession for them. The defendant's experts will also ascertain your past and future needs. However, the value of the recommendations will of course be much lower than the value of the recommendations made by your own experts, and this is where negotiation will come into play. As you can probably tell by now, obtaining the appropriate expert reports are crucial, firstly to be successful, and secondly for achieving appropriate and favourable compensation.
Suffering from a brain injury can be devastating, not only for the person who is injured, but also for that person's loved ones. It is often the case that the injured person was previously the sole or main provider in their home, and are now suddenly incapacitated and left without an income. Importantly, and aside from the sudden and unexpected financial burden the injury has created, it is often the case that the once independent person is now reliant on their family members for their care needs, and this places both a mental and physical toll on all involved. It is therefore important that you engage solicitors who have a full understanding of the nature of brain injuries and the impact that they have, both from the medical side of things and in terms of how it has affected a spouse or partner in a very significant way. Your solicitors must know who the leading experts are and be able to competently instruct them with all the relevant details so that you can ultimately obtain meaningful compensation to help you live a more independent life.
Your solicitor will hire barristers, sometimes known as counsel, on your behalf. In a catastrophic brain injury case, you will have a junior barrister and one, even two senior barristers. Your solicitor and barristers will work together as your legal team. Your barristers will advocate for you in court, prepare some of the legal documents that must be filed in a case such as this, and provide legal opinion on whether or not you have a good legal case. They will also advise your solicitor in respect of the steps to be taken to overcome certain issues that may crop up along the way. Finally, your barristers will be the person or persons who negotiate a settlement of your case if it does not go to trial. Therefore, it is equally as important for your solicitor to hire barristers on your behalf who are not only experienced in handling personal injury matters or medical negligence matters, but also have an in-depth experience of dealing with complex, catastrophic brain injury claims.
The vast majority of cases end up settling outside of the courtroom. However, there is never a guarantee that a case will not go to trial. If a case does proceed to trial, the judge will hear evidence from each party and each of the parties' expert witnesses. The judge will then decide whether or not to make an award in your favour. If a case is settled or if an award is made by a judge, then typically the insurance company for the defendant will make the payment in the case of a personal injuries claim, and the State Claims Agency will make the payment in the case of medical negligence claims. If you have been successful with your claim for compensation, then you may receive a lump sum payment or an interim settlement or periodic payments. Although the courts are currently not disposed to making periodic payments, we will always engage an expert to secure their view on this point. If you have full mental capacity and if you are over the age of 18 years, then you can spend this money how you see fit.
Our clients often use the funds to build a fully accessible house or home, purchase an accessible car, pay for private care hours and private medical treatments, or indeed purchase equipment to help them live more independent lives and to also allow them to resume old hobbies or even new ones. If the claimant is under the age of 18, then the funds are typically lodged in the High Court until the child turns 18. In the meantime, the child's next friend, typically the parent, will be permitted to take out monies to cover the child's expenses and to make big purchases for housing and equipment, just to mention two matters. Advice should be secured from a tax expert to ring-fence any monies that are secured in a settlement so that tax is not paid on any income that is generated by the investments. We always say that no matter what is recovered, it is never enough for what has occurred, but the lump sum helps to give security and capital to launch a new venture on the back of any confidence that has come with the case being at an end.
Finally, we are now going to go through some of the first steps that you should take if you are considering taking legal action in respect of your brain injury. If you're aged 18 years or over, you only have 2 years to lodge a claim from the date of your injury in normal circumstances, although there are some limited exceptions to this. One of the first things that you should do is to make contact with the solicitor who can advise you whether or not you might have a claim, and they can crucially start the work on lodging your claim within the 2-year time frame from the date of the injury, and if necessary, make arrangements to preserve any evidence. If you are inquiring on behalf of a child who is below the age of 18, then the time window is much more extensive. The statutory time limit of 2 years only starts from when the child turns 18. The child's next friend, who is usually the parent, has the ability to bring a claim on their behalf at any point in time if they are under the age of 18.
Another early step that you can and should take is to write down all of the details that you can recall. A loved one can also do this for you. This can be a particularly difficult exercise to do after experiencing such a traumatic event, but it will be of tremendous benefit to your potential new solicitor, and it will assist them with the process of taking your formal instructions. It is important to note crucial details such as what you were doing on the day of the accident or injury, the timing of those activities, how the accident occurred, who you were with, and what medical services you immediately received. The sooner you write those details down, the better. Another step you can take is to possibly expedite the early stages of the investigation is to obtain all of your medical records, radiology and reports from the hospitals you attended, and indeed your GP. Information on how to obtain these records will be available on the hospital's website.
We're now going to talk about how we in McMahon Goldrick Solicitors approach these types of claims. We understand that clients who have suffered from a catastrophic brain injury have very specific needs and concerns. We purposefully maintain a very low number of files so that individual attention can be given to each client. We have over 60 years combined experience, and we only deal with catastrophic injuries, so the specialist nature of our office allows us gently glide over hurdles that others may, with the best will in the world, procrastinate about. Over the years, we have established professional connections with the top medics and expert witnesses who are involved with these types of cases. And our clients are informed in real time of any developments, and they get their case heard as soon as possible, but without taking any shortcuts.
Without ever losing sight of the sensitivity of the injury, we go about our work in the empathetic and honest way, completely aware of how difficult and anxious having a catastrophic injury is. Clients regularly confide in us and share private matters with us. We respect that. What we want to do is to walk in the client's shoes with them. Please, as always, email or telephone us with any queries on a non-committal basis. Thank you very much for watching this video.